Good evening. My name is Kelly Hendricks, and I'm going to be sharing with you about issues of conflicting rights in public schools, and specifically speaking about the Fourth Amendment rights of students. First, what is the Fourth Amendment? The Fourth Amendment is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This is the definition I found on the Library of Congress website, last updated 2021. So the question I have for you today is, a teacher suspects that a student has illegal drugs or illegal drug paraphernalia in their possession while at school. Is the teacher allowed to search the student for the suspected items? Let's find out. First of all, the arguments. The student argues that a search of their person and their possessions violates their Fourth Amendment rights, while the teacher argues that they have the reasonable suspicion to conduct the search and that they are fully within their legal rights to search the student and the student's possessions. So who is right, the student or the teacher? My analysis includes 4 major legal cases that have made an impact on Fourth Amendment rights of students in public school. These 4 are New Jersey versus TLO, Stafford Unified School District Number 1 versus Reading, Cell Phone Privacy, GC versus Owensboro Public Schools, and State of New Jersey versus Thomas E. Best. I am specifically going to be looking at the first 2 today, New Jersey versus TLO and Stafford Unified versus Reading, as they relate more to my question than the final 2 cases. So the first case that I looked at, New Jersey versus TLO. TLO was a 14-year-old female student at a New Jersey high school. A teacher had found her and another student smoking in the girls' restroom. Obviously, this is a violation of school rules. So the teacher brought the 2 students down and questioned them. The second student admitted to smoking, where TLO denied the allegations. The administrator then accused TLO of lying to him and demanded to see her purse in an attempt to find the cigarettes. Among other things, when the administrator opened her purse, he found a pack of cigarettes and cigarette rolling paper. Due to the fact that the administrator knew the cigarette rolling paper is used to smoke marijuana, he now suspected TLO of marijuana use. So he further searched her purse and found a small plastic bag containing a grass-like substance and items that could be drug paraphernalia. So then the administrator contacted the police, who in turn contacted the student's mother. Her mother brought her to the police station, where TLO then confessed to selling marijuana. So what did the court say in the case of New Jersey versus TLO? In a juvenile court, TLO argued that her Fourth Amendment rights against unreasonable searches and seizures had been violated. However, the court sided with the school, and TLO then took her case to the New Jersey Supreme Court. In this case, the Supreme Court found that a public school official is subject to the Fourth Amendment, but is not required to adhere to the same principles as law enforcement officials. So, takeaways from this is that a search must be reasonable at its inception. The scope must be reasonably related to the purpose of the search, and the search must not be excessively intrusive in light of the age and gender of the students involved. But that principal did have the right to search her possession and property. The next case we'll look at, Stafford Unified versus Reading. What happened in this case is a little bit more alarming to me. After escorting 13-year-old Savannah Reading from her middle school classroom, Assistant Principal Wilson showed her a day planner that contained knives and other contraband. Savannah admitted to owning the planner, but said that the contraband was not hers. He then produced 4 prescription strength and 1 over-the-counter pain relief pills. She denied knowledge of them, but then Wilson said that he had a report that she was giving pills to fellow students. She denied this and agreed to let them search her belongings. Then he and Helen Romero, an administrative assistant, searched Savannah's backpack. They found nothing. Wilson then had Helen Romero take Savannah to the school nurse's office to search her clothes for pills. After Romero and the nurse, another female, had Savannah remove her outer clothing, they told her to pull her bra out and shake it and to pull out the elastic on her underpants, thus exposing her breasts and pelvic area to some degree. No pills were found. What did the court say? Redding's mother sued the school district and several school officials, arguing that the second strip search violated Savannah's Fourth Amendment rights. The school denied that such a violation occurred. That individual school officials further argued that they had qualified immunity from such a lawsuit. The Supreme Court clarified that strip searches are subject to a heightened scrutiny. The evidence here was sufficiently plausible to warrant suspicion that Savannah was involved in pill distribution. So it was okay in this case. They said there was sufficient suspicion. And it was okay to search her backpack and outer clothing. They did not say anything about her inner clothing, which I think may have gone too far personally. However, what does this mean for schools? Although a search may be reasonable at its inception because there is a moderate chance of finding evidence of wrongdoing, as the scope of the search becomes more intrusive, both the justification of the search and the likelihood that it will result in the discovery of evidence needs to be compelling. So some of the lessons that we can learn from these court cases are that students' search and seizure cases are highly fact dependent, so it varies from case to case based on the evidence and facts in each case. However, the standard remains that school officials must have, and this is the big one, reasonable suspicion to search a student and or his or her possessions, and that as the level of intrusiveness of the search increases, so must the school official's justification that the search is necessary to preserve a safe learning and working environment. So the more intrusive you are, the greater level of justification you are required to be able to show. Most student searches in schools begin as a result of some reasonable suspicion by a school district employee that the student has violated a law or school policy. In order to have reasonable suspicion, a school employee must have facts that support the suspicions are true. So a justifiable search is one in which a school employee has made specific observations or knowledge, had rational inferences that were supported by all observations and facts, explained how the available facts and rational inferences provide an objective basis for suspicion, when combined with training and experience of the school employee, which that is something that I would like to see more of, training for teachers. And then the fourth one, the information of knowledge possessed by the school employee must come from a valid and reliable source to be considered. These can include observations, reports of other school officials, reports of eyewitnesses and victims, and or informant tips. A justifiable student search must include each of the following components. Reasonable suspicion, again, must exist. There must be a direct connection between what they are looking for and the suspected infraction. There must be a direct connection between what is being sought and the place to be searched. And in general, school officials cannot search a large group of students just because they suspect that a policy has been violated. So my personal thoughts on this situation, back to my question, was can I, as a teacher or an administrator, do we have the right to search a student? So I was happy to learn that it is within my rights as a teacher to question and search a student within reason if I have reasonable suspicion. There are many times this past year where I have suspected that a student had illegal drugs, drug paraphernalia, or a vape pen on them. but I was never sure what was within my legal rights to do about it. And I learned that as long as I have that reasonable suspicion, questioning and searching a student is okay and does not violate a student's Fourth Amendment rights. However, I do feel as if it is a good practice to either take that student to the office or to have another teacher present at the time of the questioning and the search if possible. Having a witness present is important for the safety of the student and the teacher. All right, so I got my information from the Library of Congress online, from an article online, Search and Seizure in Schools and Fourth Amendment Rights by D. Meador, and then 4 cases that impact the Fourth Amendment in schools by Scungio and Coate. Thank you for listening to my presentation. I hope that you have learned a little bit about students and their Fourth Amendment rights. Have a good evening.